Hello, I'm Bethan Harris. I'm a barrister at Garden Court Chambers in London. I specialise in social welfare law, including community care law. And today I'm going to talk about Part 1 of the Care Act 2014. The main provisions of that part are largely going to come into force on the 1st of April 2015. However, there is an particularly important part of the Part 1 of the Care Act which won't come into force until April 2016, and that is the cap on care costs. The aim is to consolidate, modernise and generally improve in terms of structure and simplicity the law of adult community care. There's a general consensus that the current law, which we've had for some time, is overly complex, it's not accessible, and the terminology is very outdated. There are a set of general duties which include, first of all, the duty to promote the well-being of the individual, that's in Section 1. There is also a duty to prevent or to take steps to contribute towards preventing the development of needs. And there's a duty to maintain a service for providing advice and information in the local area about community care services. There is also a power at Section 19 to provide community care services or to meet needs for care and support where those needs haven't been assessed as eligible needs or where the individual concerned is ordinarily resident in another area. So that's a power rather than a duty. And staying with Section 19, Section 19 also provides that services can be provided on an urgent basis before any assessment has taken place. It's very much the policy of the Act that services will be tailored to meet people's needs and will try to reflect their preferences as far as possible. So the Act doesn't provide a definitive list of the types of services that may be provided in order to meet needs. So local authorities to date have had some discretion with regard to what severity of need they will meet. With the new system under the Care Act 2014 Part 1, there will be no local discretion and there will be national criteria which will apply across the board. The criteria are very different to the FACTS guidance, and one has to look to the regulations, the eligibility regulations 2014, to find the detailed criteria. What we have here is a test which poses first of all 3 questions: whether a person has needs relating to a physical or mental impairment. Secondly, whether as a result of those needs, a person cannot achieve 2 of the outcomes or more in the list. And thirdly, whether those needs have a significant impact on the well-being of that individual. One of the problems, as mentioned in the current system, is the extent to which people can find themselves liable for a huge amount of care costs later in life. And this was the concern of Sir Andrew Dilnot and the Commission on the Funding of Care and Support. Implementing the proposals arising from that commission, we will have a cap on care costs, which will come into force from the 1st of April 2016. The cap will be set at £72,000. Section 11 of the Act contains an important clarification with regard to the duties of local authorities with regards to conducting assessments of needs. Where the person refuses to be assessed, generally there is no duty on the local authority to conduct the assessment. That's what Section 11 provides, but with 2 provisos. If a person lacks capacity to consent to the assessment, and the local authority considers that it's in that person's best interests that there should be an assessment of their needs, then there is a duty to conduct the assessment. Also, if the person is experiencing or is at risk of abuse or neglect, then there is a duty to conduct the assessment.